Hey, I'm Chris Stoy, and I'm here with Rafe Foreman. We're a couple of the Warriors for Justice, and today we're going to do a video on how to prepare for a car wreck deposition. Now, there are generally 5 topics that I like to cover with my clients, Rafe, and we're going to divide these up. How the wreck happened, the injuries and treatment that you went through as a result of the wreck, how you're affected by the wreck, meaning what you could do before but not do after, the priors that you may have had, so any prior injuries or claims, and then finally random questions that I've found the defense ask. It's time and time again, and I just want to make sure my clients are prepared. So we've kind of met before this, and I think we've divided up some of the topics, and that first one is how the wreck happened. You, in my opinion, are one of the best on giving advices about telling someone's story. So can you take over from here and kind of explain to our clients how they best tell their story about how the wreck happened?
Sure. Of course, we want you to document anything you can. I know a lot of people think, well, the police report's going to show how the wreck happened. Let me tell you this, and please hear me. Police reports are often wrong. As a matter of fact, I've never seen a complete police report. They lack information. They have wrong information. We can't rely on the police report. So pull that cell phone out of your pocket, record whatever is going on after the wreck, not while you're driving, please. And maybe just make yourself an audio statement about the light was green, I was rear-ended. And then if you talk to witnesses, please tell us their name, their address, and what they saw. The reason that's important is because the defendant's going to have quite a different version when we go into the case in the litigation than you do about what happened. They're going to say, well, yeah, I rear-ended her, but she stopped short. What does that mean, stop short? You have a duty to keep a safe, clear distance and not rear-end somebody. But the main reason, Chris, we need to know about how the wreck happened is because it goes to the story of the witness and the story of the case. And we're going to talk about that a lot today. The person with the best story and the most credible story wins.
Right. You were one of my teachers at the Trial Lawyers College, and I remember you teaching me that compare a story that has all the 5 senses, seeing, tasting, all that, and put it into a story, and it just makes for a better story. And what you taught me was that tends to make a story more credible. Is that right?
That's exactly right, and it's because it's the human factors. You can't beat the humanity out of the case. And so everybody's been late to work, everybody's been drinking coffee while they were driving, everybody's been texting on their cell phone or looking at their map for directions. And everybody has seen people do that. So we want to find the human connection, because we got to connect to this jury who are made out of human beings, and we want to connect to them on things that are familiar to them that they've experienced in their life. Because when you can connect on the human factors, it makes your story more credible, more believable, and obviously more powerful.
I think that's something you taught me before, and that was scene setting. Can you say more about that in terms of how our clients can use scene setting when describing how the wreck happened to the defense attorney who's taking their deposition?
You bet. What we do, as you know, is we do reenactments. We would like to have been at the scene so that we can experience it ourselves, but we weren't there. But we can be there in our office because we can have you reenact the scene from your perspective, and this is called point of view. We could reenact it from a witness on the coroner's perspective. We could reenact it from the other vehicle driver's perspective, and we reenact it so that the truth comes seeping out of the action. Now, there's another reason that you want to reenact a scene and do scene setting, because that goes back to the human factors. We all have a sense of sight, smell, taste, touch. We all have common emotions and feelings, and when you can relate to those, it becomes a familiar story. And a good friend of ours, Josh Carton, taught me that if the story is not about the listener, they won't listen. And so how do you make the story about the listener? You put them in the scene. And that's why scene setting is so very critical, because if the listener, i.e. the juror, can see themselves in this scene and it's familiar to them, it's more trustworthy, more believable, and more powerful.
I like that. Let's take it for example. In most of our car wreck depositions, our clients are asked a very broad question, and the defense attorney will say, in your own words, Mr. Foreman, please tell me how the wreck happened.
Right.
How would you do that? Because I've seen some clients in the past say, I was rear-ended, and that's where they leave it.
Right.
That to me is insufficient. So I toss that to you. In your words, Mr. Foreman, how did the collision occur?
Well, and if I may contrast to what you just did, you said I was rear-ended. Well, that's one way to do it, but both you and I feel like that's less effective.
Absolutely.
And so what I would do is I would start, and this is what John Nolte told me, is that we have to go to the situation that precedes the one we're talking about. What caused us to be here? Okay? So now let's go set the scene. I got up plenty early this morning, and I wasn't in a hurry. I had my coffee while I was watching Good Morning America, and I was not drinking coffee while I was driving. I was aware, I was alert, and I noticed that somebody was behind me, following me uncomfortably close. I tapped my brakes a couple of times. They still did not respond. As a matter of fact, I saw a red light coming up, and I started slowing down well ahead of time. Finally, I had to stop. Boom, hit me in the rear. That's exactly what I experienced.
Yeah, and that's so much more vivid and so much more descriptive than I was rear-ended. I even remember you telling me to ask the client what was on the radio.
Absolutely.
That lends credibility to the story. If they can remember it was Tom Petty or some other, maybe a podcast they were listening to, it just kind of puts it in perspective.
That is such a good comment you're making there, because it's called anchoring. How do we think about it? When you hear a song, do you think of something that you were doing at the last time you heard that song?
Oh, yeah.
That's anchoring. And so you begin to associate things with this song that have nothing to do with the song, but that's what you were thinking and feeling at the time. Same thing happens in car wrecks. And so I've often had clients say, I'll never forget it. I was listening to KLLL radio, and Alan Jackson's song about skiing in the lake, I forget the name of it. Chattahoochee.
Yeah.
He's skiing on the Chattahoochee, and that has nothing to do with the wreck, but you remember what you were doing because it was a traumatic event. And let me tell you what this is about. This is why we need the scene set. This is why we need to tell a story, and this is why people can remember what was on the radio. It's called imprinting. Mm-hmm. I'll give you an example of in the horse industry. When a baby horse is born, they touch it, they comb it, they put feed up to it to smell it. They introduce this horse on the very first moments of his birth to everything he's going to experience in the rest of his life. Then when he grows up, he's not as scared of hair clippers, he's not scared of combs, he's not wild and buck, and you don't have to ride him like a buck and bronc, because he was imprinted. Mm-hmm. Our stories imprint on the jury. Let me give you an example. I've tried cases 33 years ago. Some of them, I couldn't tell you what the case was about. There was no story.
Yeah.
Some of them I can tell you word for word what happened, and that's because they had a powerful story that imprinted on me, and I'll never forget them.
Absolutely. I agree completely with that. Well, let's move on to injuries and treatment. I'm going to take this topic for a little bit, but please throw in your comments. So for me, the most important thing, and I tell my clients this, know the medical, know the medical, know the medical. And by that, I mean, know your treatment timeline. Or maybe you have created a timeline that you can use. And that's showing, it's not knowing everything in the records, but it's knowing that here's the day the wreck happened. That day I went to the hospital, or maybe you didn't, but 3 days later I went to the chiropractor, or maybe I went to an orthopedic doctor. Know what the doctor at the hospital told you to do. Know, and this is very important, know what injuries you complained of at the hospital versus later on down the line. Often with soft tissue injuries, what initially hurts is not the prevalent pain later on down the line, and that's because of something called distracting injuries. Mm-hmm. So if my knee hit the dashboard really hard and is really banged up, I'm not going to feel the cervical restriction because my knee's really hurting. But once that knee pain goes away, the neck pain starts setting in. Where I see my clients get cross-examined in an effective manner when they're not prepared is not being able to explain why it is that they didn't complain about neck pain at the hospital, but then 6 days later at the chiropractor's office, they're complaining about it.
That's right.
The defense takes those inconsistencies and makes a mound out of a molehill, and I'll say that phrase many times because that's what they're doing. The defense is trying to distract or make your case look less credible. So know the medical, know the dates you went, know the number of visits you had to the doctors, because the defense always likes to ask, do you know how many appointments you had? And when you can say 46 without blinking, kind of takes them back, right?
That's right.
And again, know the injuries that you sustained when they came up. Know which doctor referred you to which doctor. I've even seen some defense lawyers ask, well, where's that? What's the address of that doctor? Why are they doing that?
Because they're trying to test your credibility and veracity. They want to know if this was really their doctor, which they would know the address to, or is this some sleazeball, cheeseball that your lawyer sent you to and you don't even know where his address is.
Absolutely. And you don't have to know the exact address, but dang sure know the street, what area of town it's located in. They do that to make you seem less credible. Know the number or the amount of medical bills. This is a very important thing. You're asking a jury to compensate you for medical bills, and you're going to be deposed, and the defense is going to ask, what are your current medical bills from this wreck? If you look dumbfounded and I don't know, well, so you're going to go down to a courtroom and you're going to sit in front of a jury and you're going to tell them that you want medical bills or medical expenses and you don't know your own bills.
Not going to go good.
Does not look good. Know how much of your bills have been paid and who paid those bills. Know how much is owed. So if you had health insurance that paid your bills, you need to know how much was used there. You need to keep in mind that you owe that health insurance back. That's called subrogation, which I discussed in another video. But again, know the medical, the timeline, the number of appointments, the bills, and you should be pretty good. We've talked about this before. This is a kind of a theory I came up with, or an analogy about getting A's on tests, right? So
I like this analogy.
Thank you. For me, the client, or let's take it back to when we were all in high school or whatever, the person who studied the most seemed to get the best grade. So the client who studies the most, knows their medical the most, knows their case the most, tends to get the best grade on their deposition. And in a personal injury case where the only thing that we can go after is compensation for what happened to you, that A translates into compensation, which is what we're going after. It also means that your case is probably going to get resolved quicker because you showed that you knew what you were doing. It just makes the process better all around. So study hard, get the A. I mean, some people are going to get the B, and that's okay. Just make sure you don't get the C's and D's. Next topic we're going to move on to is how the wreck affected you. And I've got this is one where I see all the time, and I'm going to pitch this one to Rafe, but the key question that they always ask, the defense asks, it's almost like they went to a college where they were told to ask this is...
No, that's what they do.
Yeah, probably so. Is, sir, what could you do before the wreck that you now can no longer do, or that you do with difficulty?
Wow, when you put me on the spot like that, it's difficult to come up with a list. I might be able to think of 2 or 3 things, but I can't think of all of the things. And so I want you to understand the concept of less is more. I'm less concerned about you can't go to Six Flags or Astro World, if they still have it, I'm not sure.
I don't think so.
Or you couldn't go on vacation to California or whatever, as I am, I can't ride in a car without a pillow behind my back because the tingling goes down to my legs and it makes them go to sleep. I want to know that I can't go to the bathroom without shaking, trembling. It's hard for me to get up. Matter of fact, I'm going to have to install a handrail to help assist me. I can't tie my tie. I can't button my shirt. those little everyday things, again, are the human factors that people relate to.
Absolutely.
That's what we want to know about. And when you talk about how's it affected you, it's affected you every 24 hours in a day, 7 days a week, 365 days a year. Why would you just limit it to one vacation in your life?
Absolutely.
That's just wrong for us to allow a plaintiff to do that.
It is, and the beauty is in the details. It is. And when I have a client who can go on and on and on about the ways that this wreck's affected him, the jury or the defense lawyer is just continuing to scribble, just writing it all down. And these help you. What the defense lawyer is trying to do is get a list and then hope that you try to come up with more stuff at trial, which naturally you will, because who on earth can think of all the ways that a wreck's affected them? And then they'll say, well, now when I asked you in your deposition how this wreck's affected you, you didn't mention these 5, 6 things that you're now mentioning at trial. That can kill a case. That can affect credibility, which we discussed in another video. But the point is by listing all these things, you then allow yourself to talk about them in front of the jury.
That's right.
I think you got to be careful, and this applies to medical. When you are asked that question about list all the things that you could do before the wreck that you no longer do, you'll start listing things, and then you'll say something key, and the defense lawyer will go off on a tangent asking you about that, and he or she may come back and ask you some more information. But at some point, he'll have compiled his own list of the things that you say that you can no longer do, and he'll read those back off to you and say, so you said you can't go to the restroom by yourself, and you can't do this by yourself, and you can't do that by yourself. Is that it? Every time, mark my words, every time they'll ask that. How do you tell your clients to answer a question when those defense lawyers ask that all-encompassing question, is that it?
Well, I want you to first of all be aware that is that it is a cancer that is going to be introduced into your body by defense counsel, rejected at all costs. And the bottom line is, of course it's not it. It might be it for this moment, under these spotlights, under this pressure, under this deposition, under the time that we have. Depositions in federal court only last 7 hours, and they have to last a reasonable time in state court. I mean, we don't have all day. And part of the reason that the client might not tell it everything is because they're nervous. They've never given a deposition before.
Started an hour late.
The guy's being mean. He obviously doesn't care.
He spent 30 minutes asking about who your uncle's cousin's brother's aunt was.
That's right. But I want to give you some insight right here to think about. Let me tell you the best way to get out of having to get the cancer of is that it, is that it, is that it. And the best way is for you to practice that before you get to your deposition. Let me give you an example. The medication, this would be from a client. The medication that I have to take makes me drowsy. I used to read books voraciously, I guess I should say. Now I can't read because as soon as I start reading, I go to sleep. Now, if you hadn't thought about that, you can't think of that in the moment under the pressure of the deposition. And so this goes to being that A+ student. This is what we're talking about studying. The reason that we ask you to keep a journal and write what's going on with you every day is because what'd you have for lunch Christmas Eve 3 years ago? Well, that's bad. You might can remember that.
Yeah, if it was my mom, I can tell you. But
what'd you have on December 23rd 3 years ago for lunch? Who knows? But if your case depends on it, we need to know what you were doing, what you were feeling. And so how it affected you has to do more with, I don't want you to just tell us I had a cast on my leg and it itched. Well, could you play your tennis? You usually play tennis. Could you play tennis? No. When they took the cast off, could you play tennis? No. Here's the key. You got to tell me why. Why can't you read books? Why can't you play tennis? Why can't you play golf? Okay, can't play tennis because my leg is weak and I fall down. I can't move around the court as much. I'm very competitive. I like to win, and I can't win playing with this leg like it is. Okay, that's great.
Yeah.
Why can't you sleep at night?
I used to sleep on my side. I'm a side sleeper, and now I can't do that.
Yeah, because my shoulder was messed up in the wreck and it hurts like all get out, and I can't sleep if I roll over on my shoulder. That is how this wreck affected you. Okay, but wait a minute.
People get that.
Let's go to the next step. You're sleep deprived. What is that doing to you? I'm less productive at work. I'm grouchy, grumpy to my kids and my spouse. Man, you see what I'm saying? And so...
And then where does that go? I mean, my brain is just spinning thinking about that. You're so right, because, then you start underperforming at work.
You might get fired.
I mean, people come in and they tell me that like this wreck led to them getting fired. And as a young lawyer, and before I was properly trained to understand all this, I was really skeptical of that. But when you put it in that perspective, it absolutely holds true. But guys, it is y'all's responsibility, and ours as your lawyers, to make sure that story gets told. Don't just say, oh, I was fired because of this wreck. Follow Rafe's advice of let's follow the trail. I love that. That's beautiful.
Yeah, I really mean it. We're not trying to get you to act or make up things, but we're trying to get you to fully and accurately report what's going on with you. And don't be worried about, well, that's a little thing.
No.
What are you talking about? Less is more. And the way that you get out of having this cancer affect you in the deposition, what else, is you say, there is so much, it is impossible for me to make a concise list.
Yeah.
It would take more than the time we have in this deposition for me to tell you all the ways that this has affected me. And when they see that, oh my gosh, you've thought about this, they move on to the next question. That's the best way to get out. Remember, offense, the best defense.
Absolutely. Well, the next topic that we're going to go on to is fully disclosing your priors. And by that I mean could be prior crimes, prior claims, prior injuries, anything that happened prior to the wreck. And I'm going to tee that one up to you, because credibility is a big issue to you.
It's a big issue. Susan Hutchison, partner in the firm, used to say that her father would always say, I've had worse than that in my eye. And that is a really pervasive attitude that we have in Texas. People don't want to whine, they don't want to complain, they minimize, they don't tell their neighbors or their family or anybody what's going on with them health-wise. They're sure not going to tell strangers. Well, here's the problem. You train yourself not to complain, not to report, and you forget. And so when they say, have you ever been to have surgery before? And you're thinking, well, I hadn't really had any significant surgery. No. Well, wait a minute. You had tonsillectomy when you were a sophomore in high school. Well, that didn't have anything to do with the wreck, but if you lie about it, now it comes in to impeach you. And so it's absolutely essential and critical that you scour your mind and your family. And I'll have to tell you, I know a lot of people don't remember their own medical treatments, but their spouse will. Have a conversation with your spouse and say, okay, they're going to ask me, what's my prior medical history? I've got to tell them, even if you don't think it's related. For example, maybe you had a colonoscopy where they checked and everything was clear, everything was fine. And you don't want to put that on there because you can't possibly see how that relates to your car wreck. It's not your job to see whether it relates to the car wreck. It's our job. And what we're trying to do is to not expose you to being impeached on collateral matters that don't matter. On another segment that we did, we talked about discoverable evidence and admissible evidence, and this goes to the heart of this issue. Let us decide, let us fight for you, let us protect you, but you fully disclose. Even if it's getting your wisdom teeth taken out and you can't possibly see how it relates to the accident. You know what? We can't possibly see how it does either. And we'll tell that to the judge, and hopefully the judge will leave that out of the trial. But if you say, I've never had a medical procedure, well, now your colonoscopy's coming in to show you're a liar, your wisdom teeth coming in to show you're a liar, and those are collateral matters that have nothing to do with what we're doing in court. So let's not bring this to the fore of bringing those into court with us.
Absolutely. And I think to be thorough, that the viewers should watch the discoverable versus admissible evidence video.
I agree.
To really understand that.
And I'd like to give them one warning.
Yeah.
Every pharmacy in the United States can print a list of every drug you've ever been prescribed. Why would you ever lie about that or forget about that? Or, maybe you don't realize that they're keeping track of this stuff, but they are. Mm-hmm. And so we cannot lie about it. We just want you to tell the truth. It's going to be okay. And I want to talk about a sensitive issue just right fast. Prozac. If you were on Prozac or other drug for depression, I can understand why you wouldn't want that to come into court. We will fight to keep that out of court if it's not relevant, but we still have to tell about it. We cannot put your jeopardy or your veracity in jeopardy. And this is so important that we have a segment I'm going to refer you to called Credibility Kills. I'd like for you to watch that because it has to do with this issue right here.
Yeah, that reminds me, I've had clients that because of something that happened in their life, they maybe tried Prozac for like 2 months, which probably isn't even enough for it to take effect in the body. And they're like, well, I don't need to disclose that. Yes, you still have to disclose that. I'm not saying that it's admissible, and it probably isn't, but if you don't disclose that, then they're going to make it seem like you were trying to hide that. So mm-hmm. I agree with you. Yeah, the fact that you were on Prozac for 2 months is pretty ridiculous. Jury doesn't need to know that, especially since it happened 8 years ago. But disclose, disclose, disclose. And we talked about this in the other videos about admissibility and credibility. I can't remember which one, but if there's something that you absolutely feel like you shouldn't disclose or that you absolutely do not want to disclose in a deposition, then please, if it's, say you were sexually assaulted as a child and the defense is somewhat getting into that, you can say, I'd like to take a break and I'd like to talk to my attorney. We're going to allow for that. We may make an agreement with the defense lawyer or tell them, hey, we think this is too intrusive and we'd like the judge to rule before we allow this to go any further. But you can do that. Just don't use that as an out, right?
Yeah, I agree. What you said made me think of something that I just want to say to our clients. A trial is supposed to be about what happened here, not what you've done 20 years before we got here.
Yeah.
Let's not make it about what we did before we got here, and let's just accurately, honestly, and completely talk about what brought us here today.
Yeah. So the next topic that we're going to move on to is random questions that I've seen come up in car wreck cases. The first, I think I already addressed, is to know the amount of medical bills, know what has been paid, who has paid it, how much is owing, and what your total amount of medical bills are.
May I interject a question?
Yes, sir.
Because as a client, I'm feeling kind of nervous. I can't remember all that.
You can write
I
it
have
down.
notes?
You can.
Oh, okay, I feel better.
So you can have notes at the deposition, including a note, if you even want, of all the ways that this wreck's affected you. But bear in mind, any note that you take into the deposition, the other side can take, mark as an exhibit, and cross-examine you about it. And I always let my clients know that, but absolutely, if you want someone who wants to have that note, feel free to do that.
So should I refrain from putting on my notes derogatory comments about opposing counsel?
As your lawyer, I would advise you not to do that, but part of me wants to see some of the derogatory notes that people would write.
We'll talk about those back at the office.
Yeah, we won't make any videos that the defense can find on that, but I would probably agree with you on some of those. Mm-hmm. Next issue is letters of protection. So a letter of protection, you know this because you've already retained our services. The letter of protection is an agreement between our firm and the doctor that says that the doctor will treat you and agrees to be paid from the proceeds of the at-fault party's insurance company after the case resolves, whether that be settlement or at trial. Now, these are the skunk in the jury box type issues. Some judges let the defense talk about letters of protection, some do not. You need to assume that the judge is going to let the defense talk about the letters of protection and be prepared and answer your deposition questions accordingly. So, you dang sure need to know what a letter of protection is because they will ask you, what is a letter of protection? So again, it is an agreement between my firm, or I'm going to be you. So it is an agreement between my attorney's firm and the doctor that says that I'm allowed to get treatment and that the doctor is paid back after the case resolves or we win at trial. They'll ask, why did you use a letter of protection? Here's why. Or here's why I think you use a letter of protection. Because you, the person who didn't do anything to cause this accident, was injured by someone who has auto insurance, and that auto insurance should pay for your injuries. Why should you come out of pocket, even if it's co-pays, to pay for injuries or medical treatment caused by someone else? Do you agree?
I do. I want to give you a caveat though. You can't say what he just said in trial. We're talking about saying it in the deposition.
Absolutely.
So everybody be clear about it. But it's not fair for the injured party who did nothing wrong to have to shell out all this money for their treatment. Just because the wrongdoer won't accept responsibility and or his insurance company won't pay their just due because they're just putting profits before people.
Yeah, absolutely. But in your deposition, yes, you can say, why should I do this?
I just want to make sure that we're talking about depositions here.
But I bet if that's your answer in deposition, it's not asked in trial.
Right.
That's my thought.
I agree.
They will ask you, since you used a letter of protection, do you even care how much your medical bills are? Yes, you do, because technically you are still on the hook for these medical bills if this insurance company screws you over, goes out of business, can't take care of the medical bills. So you do care how much they are.
See, I love that question. Ask that to me.
Do you care how much your medical bills are?
I care as much under a letter of protection as I would under my insurance policy or your insurance policy.
Why so?
Because they're treatments for me, and I want to make sure they're accurate, justifiable, authentic, and necessary.
Agreed. That's a great way to handle it. If you can do that, please, by all means, answer it Rafe's way. Another issue that they talk about is future medical. A doctor may have opined that you need future medical treatment. And as you sit there, it's been 1.5 years since the wreck, and maybe you haven't treated in a few months, but I almost guarantee you that you have flare-ups from this wreck. Flare-ups, we talk about this a lot. A flare-up means you're not constantly in pain, but every now and then that pain from a wreck comes back up, and it needs treatment. I dated a girl once who was in a wreck like 10 years before I dated her, and she was in her early 30s, and she was talking about how that wreck was still affecting her to the extent that when she wore a small, even little necklace, that it made her neck hurt. And I remember, I will never forget that, and I always tell my clients that story, and I want them to remember that. Mm-hmm. Like, you don't know if you need this future medical treatment. A doctor who's seen patients for years and years and years has given the opinion that you probably will need that medical treatment based on what he's seen. You're not hurting today necessarily, but you have those flare-ups, and based on what he's seen, you probably will need the treatment. And say they have say there's an estimate for a future surgery, and maybe it's $50,000, and it's for a fusion, a really significant surgery. Now, most people will admit, and I'm sure you would too, that no one really wants to undergo a giant surgery, right? Like a fusion where they open up your back and they put hardware in. But how about this? Think about this. When you go to trial, or when you're trying to resolve this case, that is the only time that you can get compensation for that future treatment.
That's it.
So when they ask, are you going to get this future medical? Are you going to get this surgery? You don't know for sure. How would you answer that? You know, Mr. Foreman, I see here that a doctor has said that you need an ACDF fusion in all probability within 15 years. Now, do you intend on getting that fusion?
It's going to depend on a lot of factors. Where I am in my life. Let's say I get stage 4 liver cancer and it intervenes. I might not get the surgery. Let's say that I need to continue to work and be free of pain. I certainly may get that surgery. I can't look in a crystal ball and tell you what's going to happen in 10 years from now. I can tell you that today my doctor says I need it, and that's not going to change. That's what we're dealing with.
Yes, absolutely. I love what Rafe does here, and I add in, I'd like to have the option.
Yeah.
I'd like to have the option.
Yeah, I didn't need this option before your client ran into me.
Yeah.
But I'd like to have that option now since it's necessary according to this doctor.
Absolutely.
I like that option idea.
Yeah, and it's truth. I mean, you do want to have the option. And after the jury renders the verdict, and I tell the jury this from time to time when I'm asking the jury for future medical is, you know, ladies and gentlemen, there's no absolute certainty that Mrs. Johnson's going to need this surgery. but she'd like to have the option, and this is the only opportunity that we have to collect compensation for that future surgery.
Well, I kind of liken it to termites. You get your house treated for termites because you don't want them.
Yeah.
No guarantee you're ever going to get them.
Yeah, true.
But you still treat them for termites to prevent against it.
True.
And this is something that's needed. It's a preventative. It's to improve your quality of life. And that's something we don't talk near enough about. You had a certain quality of life before this wreck intervened and damaged your quality of life. We just want to put back to where we were.
Absolutely.
And where we were is now we need a back surgery.
Yeah, absolutely. Another thing that gets discussed is how much money do you want for this case? My gosh. So I'll just tee this one up to Rafe and see how he does here. Now, Mr. Foreman, how much money do you intend on asking the jury for in this case?
Now, are you asking me as a lawyer or a client?
I'm going to be a lawyer. I'm going to be the defense lawyer, and you be the plaintiff. All right? Mr. Foreman, how much money do you intend on asking the jury for in this case?
What's the context and where we're having this discussion?
We're in a deposition.
And you're asking me lawyer to lawyer?
No, sir. You're the client.
Oh,
You're an
okay.
injured party. I'm the defense lawyer. So,
I'm ready now.
all right, we're playing roles here.
Yes.
How much money do you intend on asking the jury for in this case?
Sir, I'd like for you to answer my question, and that is, how much money is it going to take to put me back where I was before your client hit me?
Well,
That's
I'm going to be the one asking the questions here.
Oh, hold on. I want the amount of money that's necessary to put me back before your client injured me. That's all I want. And I have a lot of doctors and lawyers that have opinions about what that is. But I will tell you, because of the pain and the suffering that I feel on a daily basis, there's not enough money in the world to make me whole. And I told that to my lawyer, and he said, so we just going to let them go because there's not enough money? And no, we're not. We're going to hold you accountable. But I want to hold you fully accountable. I want recovery for every bit of value that you took from me, because your client took it without my knowledge, without my consent, and without my permission. They stole my health. I want it back.
Yeah.
All of it.
I like it. Try this one out for me. So say the case is not worth $1 million, right? Let's just assume it isn't. Say the case on its best day is worth $200,000. The defense lawyer, I'm the defense lawyer, and I've already asked you, the plaintiff, how much you want, and you say the response that you just gave. And so to try to start chipping away, I'd say, surely you'd take $1 million for this case. How would you respond to that?
In front of a jury?
Yeah.
As a lawyer?
As the plaintiff. How would you have your client respond to that?
I wonder how many people would say, if I give you $1 million, would you let me cut your arm off?
I like that. I don't think any of them would.
Yeah, I don't either. I wonder how many of them would say, if I'm going to give you back pain for the rest of your life that's debilitating, can I write you a check for $1 million?
Yeah.
You wouldn't take it.
No one would take it.
Right. And so, sir, all I want is the full value of the damages that your client caused me. Not part of the value, not some of the value, all of the value. I don't want more than it's worth. I don't want less. I want to be made whole.
Yeah. So, see, Rafe sticks to his guns there, and we'll talk more about that here in a little bit, but the point being is the defense lawyer will keep whittling down. Well, surely you'd take at least 50. Surely you'd take this. Surely you'd take that. You stick to your guns. You don't never have to agree to an amount. And quite frankly, and I want to pose this question to you, because my clients have answered this way before, and they'd say, I'm going to let a jury decide that. Mm-hmm. Are you comfortable with your client answering that way?
Yeah, but I'd like to give an alternate version of saying the same thing. I trust these ladies and gentlemen to decide that issue for me.
Yeah, I love that. I like that.
Because what we just do there, and you need to watch this on another segment that we have, you got to make the story about the listener. I trust these jurors to make this decision. You've just made the story about the listener.
Yeah. So at no point do you have to concede. And by the way, the defense lawyer, they love doing this, right? Like, now you realize this is the only opportunity that I have to ask you questions here today, and almost make you feel guilty because you're not agreeing to the question that they're asking, like, surely you would take this much money. Never, never, never feel guilty about not agreeing to them. And that, quite frankly, that brings me to our next point on these like randomly asked questions and tips.
Before we leave that, can I just tell them the why? I believe we are to tell our clients why every time we can. Do you know why they want you to commit to a number?
I'm thinking so they can impeach you later.
Well, it's a psychological hook is what it is. And so what happens when you go to the new car store and you look at the sticker price? You express shock. And then you warm up to it, and about 2 days later you go buy the car. What happens when you're trying to buy a house and you go, you want how much for that house? And then you wind up buying the house.
Yeah.
Because they condition you to their price. If they can get you tied to a value numerically, they psychologically get you to believe that that's what your case is worth. And let me tell you, I learned this in auctioneer school before I became a lawyer. Things are worth what a willing buyer and a willing seller say they're worth on the day that it's for sale.
Absolutely.
This case is worth what 12 people sitting in this box say it's worth today. That's what this case is worth.
Well, and as a side note, I think it's important for us as lawyers to believe in the number that we're asking the jury for our client. Like, I don't know about you, but if I don't feel that number, the jury's not going to feel it from me.
I absolutely have to feel the number. And I want to say this just because there's a big bunch of controversy. I think you should tell the jury the number in voir dire.
I agree.
In opening, and then in closing. And
I agree.
I get their permission in voir dire. I say, would you like, if I'm voir dire in the jury, I say, would you like to know the number that we're seeking in this case, or do you want me to spring it on you and close an argument?
I agree.
They all say, I want to know now.
And that gets us, we'll come back to that on voir dire a little bit later, but because we're going to wrap this up on deposition prep. But that last one on the random questions, and then I'm going to conclude with a few more things, but the last one on random questions, and I want you to take this because you love that Tom Petty song, is Don't Back Down. What do you mean for that when you tell your client don't back down?
I mean, they can stand me up at the gates of hell and I won't back down. That's what I mean. I wish I'd have wrote that, but I got there as quick as I could, and I love that song. If you're telling the truth, you shouldn't have to back down. If you're being honest, there's nothing to back down from. If you're being complete, you don't have to back down. People that back down know that, well, I exaggerated that a little bit, or I might have fudged a little bit here, or I might have assumed a thing or two. People that don't back down are people that are telling the truth, because they have nothing to back down from.
I love it when my clients get animated kind of at it. I mean, I'm not saying aggressive, but animated, like, no. They take a stand and they're not going to let the defense lawyer push them. By all means, I've got your back when it comes to that. Do not back down, and we'll go down to the courthouse. We'll fight. I'll be right beside you, fighting that fight. I know Rafe will too. Like, we love it when clients won't back down, and if they want to make some kind of issue out of it, by all means, let's go down to the courthouse, right?
That's right. We are treating this as the most important case in your life.
It is.
I know you are going to treat it as the most important case in your life.
Yeah. So I want to end where depositions start, and that's the boring and mundane crap, right? So FYI, even in a car wreck deposition, the defense lawyer in a car wreck deposition only takes maybe a couple hours, whereas some of our employment discrimination or civil rights cases can take 6-7 hours. But in a car wreck deposition, even those, the defense lawyer will spend probably at least 30 minutes asking questions that you feel have nothing to do with the wreck. And obviously they'll start with your name, but this is a joke, but I swear sometimes they want to know who your kindergarten teacher's husband was. Just stuff that has no relevance. And I don't know if they do it as a way to kind of wear you down a little bit, maybe piss you off, because all of a sudden you're looking at your watch and you're thinking, why am I having to go through all this? But you got to bear with them through that, right?
My belief, yes, right. My belief, it's conditioning.
Yeah.
They're conditioning you. The entire point of a deposition from a defense standpoint is to minimize damages. They're not taking your deposition to prove fault in a wreck. they'll do that in another place. The entire purpose they're taking a deposition is to condition you to lower your damages. And so every question they ask you about your kindergarten teacher, about what you did, when you're in high school or whatever, is to get you in a negative frame of mind that I just want to get out of here and I want to get this over with. And that way, you won't fully and honestly and completely tell them how this has affected you. You'll instead say, somebody rear-ended me, my back hurts.
Yeah, wear you down. So some ground rules for depositions too, and feel free to add any if I forget. But trust me, the defense will remind you of these when the deposition starts because they can't help, and they love to remind you of these. But like, you realize you're under oath. And that means the same thing as putting your hand on the Bible or whatever you believe in and testifying that you'll tell the truth, and that if you lie, it's perjury and you could go to jail. They do that to try to scare you. All right, just agree to tell the truth and tell the truth. There's a court reporter there, so that court reporter is taking down what you're saying. She's typing, and because of that, she can't type down what two people say at the same time. So make sure you let the defense lawyer finish his question before you do your response. And he's probably agreed early on in the deposition that he'll do the same for you. So by all means, if he or she, the defense lawyer, cuts you off, you say, hold on, I wasn't done. Just insist, because and Rafe and I or another attorney at the firm would be right behind you saying, yeah, she wasn't done testifying there. We may object from time to time. We may say objection form. That just means that there's something about the question that we don't necessarily like. Now, it doesn't mean that you don't have to answer the question. It just means that we don't like it and something to be concerned about. So go ahead and answer it. Now, if an attorney ever instructs you not to answer the question, then don't answer the question. The defense lawyer will follow up and say, are you going to follow your attorney's instructions and not answer this question? And of course your answer is yes. And we can discuss outside why that's not the case. Another rule for depositions, and this is written in the Rules of Civil Procedure, I believe, is that if a defense attorney has a question on the table, you can't stop the deposition and ask for a break so that you can go talk with your lawyer outside. Like, how'd the wreck happen? I need a break real fast. You just can't do that. You got to answer that question, but you can take a break at the next question. With that in mind, breaks are allowed. It's not a marathon, so don't think that you need to sit there for 2 to 3 hours on end, answer the questions without a break. If you need them, you take them, but don't use them as excuses. That's just not, we just don't play that type of game. What other general deposition?
Don't guess.
Yeah.
If you don't understand the question, don't make up an answer. If you're not sure you understand the question, tell them, I'm not sure I understand the question. Would you please ask it in a better way or in a way I can understand? Do not guess. And let me tell you, guessing is not just about making up an answer. Guessing is, I'm not sure what you're saying, so I'm going to guess this is what you're saying. Nope, that's not the time to do that under oath in front of a court reporter.
Or the defense lawyer may even say, well, what's your best estimate?
Yeah, we're not here for that.
Not here to guess. I'm here to testify under oath.
Don't guess. Don't be argumentative and belligerent with the lawyer. Let me just tell you, one of the greatest, and we're going to talk about this on another session called Credibility Kills, but you can't be all nice and friendly when you're talking to Chris and then you talk to me and you just become Dr. Jekyll and Hyde. That's a person that the jury is not going to have credibility for. And you need to remember, maybe your deposition's being videotaped like here today. The camera's going to pick up every frown, every snarl, every sarcastic remark. There's no place for that. Let's be respectful. Yeah. And let's not be sarcastic and argumentative with opposing counsel.
That duplicitous persona that you showed reminded me of a defense lawyer I know whose name I will not mention, but he has this way of questioning clients like, now, Mr. Johns, and tries to be so friendly, like, surely you blah, 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 blah. And for an unsuspecting plaintiff, it's like, well, this guy sure is nice. No, he is probably the worst defense lawyer I know. He's not truthful. He'll cheat, lie, cheat, all that stuff. So, and don't get me wrong, there are some really great defense lawyers out there that I actually think consider, friends to an extent, I guess, as much as you can. So I'm not saying that about all defense lawyers, but by no means, even my friends, if they were acting like that to you when taking your deposition, are not doing that to be friendly. They're doing that so that it breaks down your barriers, right? Do you have any thoughts on that?
No, I absolutely do. And that was one of my criteria I talk about for depositions that I hadn't got to, and that is, think of who your enemy is. And I know I'm not saying who you hate. We're not supposed to hate anybody. But who is your antagonist and your enemy? When they ask you questions, do you hear them in a different way? Yes, you do. You need to understand this lawyer asking you these questions is your enemy or your antagonist. He is not here to help you. He is not here to help you win. He is here to defeat you. You need to understand that and process and hear and receive the questions with that in mind.
Yeah, absolutely. I mean, he keeps and gets new business by doing a good job. And if seeming friendly to you does a good job for him, then he's going to do it. And you know, we all have our way of doing stuff, but just be cautious of that. That's a concern of mine. Any other tips?
I do have one, and I don't want you to be a smart aleck.
Yeah.
And I don't want you to say this, but I want to go back to something Chris said earlier in this segment, and that was distracting injuries. If you have knee pain, one way to solve that knee pain is smash your thumb with a hammer. You'll forget about that knee pain for a while. Well, does that mean your knee pain went away? No, it does not. Does that mean you don't have knee pain? No, it does not. And so I want you to understand that you can have simultaneous pain and you pay attention to the one that's hurting the most at the moment, but that doesn't mean that you didn't have the other pain. Don't let the defense counsel trick you. That is a very bad trick, and I want you to understand it and understand why we're instructing you to answer honestly.
Absolutely. Well, that concludes it for preparing for a car wreck deposition. We, of course, if you're given a deposition, we'll spend more time with you. But thanks for tuning in. I'm Chris Stoy.
And I'm Rafe Foreman.
And we're some of the Warriors for Justice. Thanks.